We're here on Roderick Bolton.
Okay.
This is on the docket Monday and,
Was on the docket.
yeah, it was on the docket Monday,
Okay.
on the docket today. You want case number?
Sure.
It's 2551572. We originally, I was assigned to represent him on February the 17th, and he had already executed a waiver. He had a local case that's pending in court number 2, which the court granted him a PR bond on February 4th.
Wait, did you catch that? Their defense just said the sheriff's office didn't lift the hold for over 2 weeks. That's a huge procedural error. In Texas, a 14-day delay can make or break a bond ruling. So the question is, should the defendant sit in jail because of a paperwork mix-up? Or should the court step in to fix the system's mistake? Let's see where the judge lands on this one.
You guys notified the remaining jurisdiction?
So this one,
Well, this is kind of unusual.
Okay.
We were reset until Monday because that would have been the 14-day time period. For some odd reason, even though the bond, which I want to tender to you, local case was signed by the judge, defendant, and everybody on February the 14th. And it was entered on February the 15th. For some odd reason, the sheriff's office didn't
Okay, just the last one.
book the hold off of him for the local case until February the 28th.
Julie Saldana, it was,
Are you saying they didn't see the release of the hold until the 28th?
no, it wasn't made until the 28th, but it wasn't remitted to the sheriff's office until March 3rd, according to Ray. So it was set on, bond was set on the 21st, but it wasn't made until the 28th, remitted on the 3rd.
Oh.
For the local case, not for the fugitive case. Sorry, for
The local
the,
case, bond was signed by the defendant, the magistrate, and.
On the February 14th.
February
So the
14th.
hold, so the 14 days starts running that day.
That's what I said.
I don't have
This
the,
is Christie, she's the attorney representing the local case.
In court.
Yes, and I think there was an issue with the spin numbers too, but I don't know if that was.
there was a spin consolidation, that was a separate
Oh, okay.
hold. So that would have held regardless, but I'm gonna need Ray's expertise on that part, because I was asking most of the questions regarding that.
Where's he one from anyways? Is somewhere to,
Oklahoma,
Oklahoma for,
Ottawa,
yeah,
Ottawa County.
uh,
I mean, unless you have like a pre-signed waiver or, you know,
this one's
carries a life term.
first degree robbery, I don't know, I can do a quick check.
I mean, he shouldn't be held to pay for the mistake of someone else.
Code. Let's see, that one is not less than 10 years, so 10 is the floor. What is,
I'm with you, Carl. I'm not gonna let him pay for someone else's mistake, you know?
So the fugitive is dismissed.
Well, I don't know. If he decides not to, then I'll just give him a PR bond.
Okay.
well, no, I mean, in terms of, so,
Or how do you want to handle it, Dave?
hold on. Actually, the other thing I tasked Amy is to contact the demanding jurisdiction to figure out when they would be able to come.
I'm still waiting on a response from the defendant.
I mean, because we still have a couple days regardless, right?
Right.
Well, he's
So,
in court today on the misdemeanor, which was reset until March the 18th, 17th.
But you, yes.
Regardless, though, they still have a couple days for the 14 days, or is the 14 day today?
The 14 days would have been up March 3rd.
if you're going all the way back to the 15th, sure, but I contend that he
It's
didn't,
over.
I contend that he didn't make it until the 28th. Because there's still the spin consolidation even before the leasehold, so.
No, he made the bond on February the 14th. The sheriff's office, that's on them. They didn't do whatever they were supposed to do until March the 3rd or February 28th or whatever
Well,
dates
They
are
didn't
relevant.
do anything wrong. They never got the information. So they didn't do anything wrong because they didn't get the paper.
So is the district clerk's office then.
They're
Right.
He's right there. So it's the one that we talked about regarding the hold, figuring out what the hold issue was, but I don't know to the contents of it, just that the sheriff's office didn't have it. So,
Regardless, I can't,
yeah.
I'm not gonna let him pay for someone else's mistake. Whoever, it doesn't matter who it is.
No, but I'm saying even assuming going back for the dates that he had after he made the bond, is there was still a spins consolidation hold, which is different because that's not case specific, but I don't know the answer to
Here?
that.
No, right.
He's in court number
Court
two.
two.
I'd like to talk to him.
Can the bailiff bring him up
Because
to?
what I'd like to do is admonish him to let him know that
He's very confused.
we're going to release you, but that warrant is out there and it's always going to be out there and they can go and get a hold here tomorrow or later today.
Does live there. He was just here for.
So if you release him on bond, Judge, does he have 14 days to go up there to get the?
No, he's
No.
released. He can do it.
Do you need to run down to court too?
Always be there.
Okay, you want to come, you want to,
He could theoretically call them and they could issue a new one right now before he's even released.
Sorry, so because in the condition that he is released, Judge, you typically give them an opportunity to respond in lieu of them not coming. If it's a matter of just of the court admonishing.
I was going to admonish the defendant and go, look, I'm giving you a PR bond, right? Because there was a mix up.
But for the PR bond, that would necessitate a reset for a future date, which is why I'm bringing up the question. If it's an admonishment for him to return, it still needs a set date
Yeah,
for robbery.
that's right.
that's what I was asking.
Right.
But that being said, I'm double checking because it's a floor of 10 for first degree robbery. If it's life, then he is not eligible, which is what I'm still checking.
When someone gets a charge and it carries a term of life, I'm not allowed to give them a bond, no matter what.
True.
So I can't imagine on the first degree robbery it's going to be.
I mean, for our first degrees, we have 5 to life. So assuming that Oklahoma is similar, then
Well, that's
that's
true.
what I'm checking. I don't know. Yeah, well, I mean.
Well,
this
there's
is-
different degrees of robbery in the state of Texas.
This one's first degree though. This one it says on the teletype. But Google AI, however reliable that is, does say life. But let me double check though. I don't want to misspeak.
You'll sign in just a minute.
Solicitation, murder, manslaughter, robbery in the first degree, felony. You should go away. So right now with Oklahoma Penal Code. So
You speak Okie?
not well. Not well.
I don't think that, they can't read and write up there anyway.
208.
Okay, go ahead and sign, please.
You mean talking about sinners.
Robbery, 2 or more persons, a felony. Attempted robbery with
10
imitation.
years.
I'm sorry?
I got 10 years, but I don't know. It
No,
could be
it's-
wrong too.
Well, not less than 10 years, but it doesn't show the maximum. I don't think it cites a maximum,
Yeah, that's.
Just a minimum?
just a minimum. Well, some states just do that where there's just a minimum and obviously there's no ceiling. With the exception of,
Yeah, I see what you said. There's no max, which is really weird, right? It's like,
it is, but it's not the first penal code that I've seen that does it that way. But I interpret that as life in prison. If you want me to double check, I can call the ADAs there if they interpret that in life in prison. If they do, obviously it's involved.
how can you possibly interpret that as a life?
Oh, like I said, I can call the DA's office there and double check. Fine. That's why I want to, if I may have a few minutes to stand down, I can call the DA's office up there. I'll do that right now.
Judge, did you?
Any way you want it, do you want him up here, Judge? One way or
They are gonna
another?
Start picking a jury at 11 is what I was told in court too.
Is there any way we could get him, you think?
I was.
Deputy, he's in court 8. Can we get Roderick Bolton? He's down in court number 2.
Is it possible to get someone who's in court too? Please, Bolton. Do you mind giving him the cause number and maybe he can
And Judge,
bond? And then there's certain times that I cannot give someone a bond. Typically, I can in almost all situations, except for number 1, where someone signs what's called a pre-signed waiver. Let's say you get on probation in Oklahoma for a case, right? One of the conditions that you sign, you say, I agree to waive extradition in the event I ever become a fugitive.
And there it is, the bombshell. A first-degree robbery out of Oklahoma, carrying up to life in prison. That single phrase, up to life, just changed everything. The judge can't legally grant a bond if the charge carries a potential life sentence. This isn't about guilt or innocence anymore. It's pure legal limitation. How would you feel if your freedom hinged on a single line in another state's penal code?
So if you take off, you become a fugitive, you can't try to get a bond because you've already in essence, waived by signing, by getting onto the probation.
Yes, sir.
The other instance is when there is a charge where it carries a term of life
Yes,
in
sir.
prison.
This one's a first degree robbery, Your Honor. It has a minimum 10 years prison up to life in prison. So because the punishment range extends to life in prison is it states contention that he is ineligible for bond.
Response, you have any?
The response is the statute that you read has no ceiling. And it doesn't state, the
Let's do
statute
this.
doesn't state the ceiling's
I don't
life.
want to do something wrong, so
Sure.
I'm not going to set a bond now. Do, any kind of research that you may. If you find something different, let me know. I'm all ears. If you find something contrary to that, I'm always willing to listen. And then if so, I will. The problem is in your cases, typically we give other jurisdictions 14 days to come get you. In this case, someone somewhere dropped the ball where they didn't give sheriff's office notice to call Oklahoma to say, hey man, come get him. So Oklahoma really never even knew to come get you, right?
Till
That's correct.
till Monday, third.
So that the 14 days ran on the 3rd, with now it's the 5th. So that's why there was this little snafu where I was going to give you a bond today and I was ready to until they said that this now carries a term of life. So I can't. That's where we're at. So I'll have them do research to see if there's something different. If there is, then I'm all ears and we'll go from there. In the interim, we don't want you to just sit there and languish. So Mr. Kim is going to talk to Oklahoma to see how fast they can get here to come pick you up, to take you back. You need to understand one more thing is that you were on bond for a case in here. You need to stay in contact with your lawyer here, because if you don't, and you get up to Oklahoma and for some reason the bond gets forfeited or revoked here, the situation you're in here, it's going to happen over there in Oklahoma. So you'll be back over there, but then Harris County is going to get a hold on you here. So make sure you stay in contact with the lawyer so they know exactly what's going on at all times, so as to not something bad happen to your boss.
Slaughter.
Do you understand? I wanted to bring you here just to give you a heads up so you know, I mean, these are your cases. You need to know what's going on. It's only fair. So, so if you have any questions, I'll direct you to your lawyers here and they can answer anything that you may have.
So Amy just said you should talk to them. They can be here by the 17th, so we'll meet the deadline by the 18th. So they will be here the day before the next court setting here.
Okay? They'll be here the 17th to come get you.
Thank you, Judge.
Okay. So just, I guess, whatever you can on your case there, because
Right,
it could impact. Yeah,
okay.
Okay. Thank you, Judge.
thanks, Carl.
If I find anything different, I'll let you know.
Just let me know. I'm all ears, always. Good morning, Mr. Garrett. Sir, you're charged with terroristic threat of a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 25th, 2025, the officers were dispatched to a residence in Harris County, Texas for a disturbance with an unknown weapon at approximately 5:49 p.m. And upon arrival, the officers met with the complainant, who stated she is the mother of the defendant and they live together. The complainant stated that day her healthcare provider came to her residence to help her as she is disabled. And the complainant stated the defendant was in his room playing loud music, and the complainant asked the defendant to turn it down while her provider was there. The defendant did turn it down, and as soon as her provider left, he turned the music back up. The complainant requested the defendant turn the music down again, and a verbal altercation ensued over the music and money, and the defendant started to rip up family photos. The complainant tried to stop the defendant, but the defendant grabbed the complainant by her arms and pinned her against the wall. The complainant stated she did not feel pain, but that the defendant said to the complainant that if she continued to touch him, that the defendant would break the complainant's jaw. The defendant was on the scene and refused to speak to officers.
Okay. Mr. Garrett, I'm going to find that there's sufficient probable cause to go forward with your case. Do we know what mom wants?
See if a rip was attempted, Your Honor, and unsuccessful.
We have a call scheduled later this afternoon. She won't be available until afternoon.
This is a problem. I normally order in these types of cases that you're not to go back to his place. So if you don't have anywhere else to go to, what happens? You have to be careful in these situations, Mr. Garrett. So let's do this. How old are you, sir? I'm going to give you a lawyer today. I want you to talk to the lawyer so we can figure something out. I don't want to put you out on the street, but I got to protect every person here. You understand? So I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using anything, I will revoke your bond, put you in jail. Do you understand? You're not to be in possession of weapons as well. And you're not to have any threatening or harassing contact with mom. If I find that you do, likewise. You got out of jail because we gave you a free bond. What happens if we put it at 5 to 10,000? If you don't have anyone to bond you out, you'll be stuck like Chuck in there until this thing's over with. And it takes a long time just to get a 9 and go home. What's going to happen? No, because come up, Mr. Garrett. When I have these types of cases, normally I don't let the people go back. Because or do you want to talk first and then you come?
Can we step down?
Oh, yeah. So the first thing I told Mr. Garrett is that he's not to use any illegal substances and that you're going to get tested. I want you to know now that I will test you 40 days to 45 days from today. If I find that you're using anything illegal, including THC, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
Okay. When I have these types of cases, I typically prevent the person here to have any contact with or to go back to the house where the complaining witness lives. Does he currently live there now?
He does, Judge.
It's going to be a problem. So how, because what the last thing I want, Mr. Garrett, are more words to exchange and you end up with another case because there's now bad blood between you two. That's the last thing I want. So how do we prevent that from happening, Abe? What do we do?
Judge, I request that the court order no harmful injurious contact with the CW. Based on my reading of the case, it doesn't appear that a no contact order is required or warranted at this point, Judge.
From what I read, it could have been an assault that you could have been charged with in addition to this case here. What do you think? Say.
Our state would request, I mean, we've got a call scheduled at complainant Zoom. State would request some sort of cooling off periods. There would be no contact order, very dangerous cases. We usually have very cooling off periods since these are fresh charges.
Do we put him on the street though? Because essentially that's what's going to happen. He's 22, right?
Yes, sir.
Yeah.
We can also, I mean, hold off till it's just at noon.
Yeah.
If they were going to the court, I know it's be later in the day till noon.
Judge, she's at the hospital. I don't know if she let y'all know that that's where she was.
No, she
She's at the hospital right now, so that's,
Why?
I didn't ask you.
How do you know that she's in the hospital? Figure out, I guess.
Let's reapproach
So
this afternoon.
are you done? Do you have anything else to do?
The reason I came back.
So for now, let's do this. I'm going to allow him to go back. You guys get a hold of her. If for some reason she says that she doesn't want him back, let me know. I'll get in contact with him and then I'm going to modify the order so that he can't go back to the house. I'm going to assume because of the relationship, right? And I don't want to put him on the street, but if she doesn't want him back, then obviously I want to follow the complaining witness's wishes. That's what I always want to do. I don't know if she wants you back. If she does, okay. If she doesn't, but be that as it may, self-control. Because I find that you are mistreating this person, threatening, abusive in any way.
This is the turning point. The judge's warning isn't just courtroom talk. He's laying down the real-world consequences of losing control. More charges, higher bonds, and a lifetime record. You can hear the frustration. This is justice, mixed with humanity. What do you think? Tough love or overreach? Drop your take below.
And I'm going to tell you now that conduct in and of itself can violate this court order. If I go like this, is that threatening or harassing? It most certainly is, and it'll land your ass in jail. You think it's funny?
No,
Just wait till you get behind and you'll see. I'm trying to tell you that exercise self-control, because I will protect every person. And if I find that you become an issue to her, it's not going to go well for you. I will test you 40 days from today. If you test positive for dope, it's not going to go well for you. Do you understand?
Yes, sir.
Okay.
Your Honor, I would like to, the defendant has been smirking some time.
I know.
The state's concerned that he's not taking this seriously. Sorry, Your Honor. It's just-
I get it. I get it. Well, he's on notice of what he can and can't do. And the problem is that there are a lot of people on a very fixed income. And I'm going to tell you now that the complaining witness in this case, she's on a fixed income. So you go to jail with a $5,000 to $10,000 bond. Just please admonish him accordingly. Okay. So don't worry about filing conditions because it'll be with Felicia. Okay. Oh, no, Felicia, no weapons as well, please. When did we enter the order for the Moab?
We were in court last Thursday. It was initial appearance last Thursday, I believe, or
So my
Wednesday.
question to you is this, is that we have an order for protection that does not allow him to go back to the house and that continues to remain in effect,
Yes, sir.
doesn't it?
Yes, sir, 61 days.
Mr. Lopez, you need to understand this because this is very important. This is something that needs to be researched because you're entering into this agreement where you could be possibly let out within the next couple of days. However, there is an order for protection that has been entered. You're not to go back to this location within that period of time. Because if you do, you could be facing an additional violation of protective order. Do you understand?
Yes, I do.
So, life is way too short to live in fear. And it's not fair. It's not fair that anybody should have to live in fear. You know, you have significant criminal history. And everything here that you've had here is because of no self-control. What's it going to take to get you to realize that you just can't pop off like that? Is it going to take a 15, 20-year sentence to get you to realize this the hard way? Consider this when you're out there. If I say this, what's going to happen? If I do this, what's going to happen? Because you could very well be a 15 to life case the next time you pick something up. It's not hard. If you get upset, walk away. But please, don't let them live in fear. Life's too short to end up in a 6x9 box for the next 20 years. You understand? It's not fair. Especially someone who's raised you, fed you, clothed you, loved you for 20-something years. It's not fair. Consider that. You're charged with terroristic threat of a family or household member. You've worked out an agreement where they're offering you 50 days in jail with credit for the 9 days that you've done. I'd like there to be an affirmative. Okay, there is an affirmative finding of family violence in this case. You need to understand that this is very, very important because another case like this, there's an affirmative finding of family violence in this case, meaning you can never own a gun or ammunition. The other thing you need to realize is that if you pick up another one of these like this, you could be very well facing a 3rd-degree felony. And because of the pen trips, you pick up another 3rd degree, you could be looking at potentially a 5 to life case, maybe 15 to life. So that's what I'm saying. Be careful. Do you understand?
I do.
They're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement today, there's no turning back. It will go on your record. It's going to be there forever. Like I said, there's an affirmative finding of family violence. So you can never own a gun or ammunition as a result of this plea today. Also, the next one, you could be very well facing many, many years in prison. You understand?
I do.
Do you still want to do this? How do you plead to the offense of terroristic threat of a family or household member? I'm going to find you guilty. I'm going to sentence you to the 50 days, give you credit for the 9. Please, just let them be. All right? All right. Good luck, Mr. Lopez. Thank you, counsel. You too.
Also, just a moment.
Yeah.
Hold on.
There's not a moment.
I don't
Yes,
see
it was. I signed it.
I thought it was.
I only see the motion for the MOA, not a signed MOA itself.
I thought it was strong.
Your Honor, on Lopez, I just want to bring to your attention, I'm looking at deeds. I only see the state's motion for the MOA. I don't see it.
I specifically did a MOAP in this case last time. I don't know why it's not
I
signed.
thought it was addressed.
And I don't see it signed in deeds. Because the motion was on the
Signed last
26th.
time we were- I did it the last time we were here in court. The hell, I need a fly swatter. You see that?
Yeah, I do.
Do you got a fly swatter?
Oh, I don't know.
So I'd like to enter it in then,
Not opposed to it.
you know? So I want to undo the plea.
Okay.
I'm going to enter in the MOA and then we'll do the plea again.
Yes, sir.
Because I want to make sure that there's no issues with this family.
Yes, sir.
All
Understood.
right, coming up, Mr. Lopez.
You get it.
So I didn't sign the plea.
There's no entries, nothing.
Okay, so hold on, let me do the MOA first. So I'm entering in what's called a magistrate's order of emergency protection that identifies Ms. Solis as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Bower Creek residence. Do you understand?
Yes, I do.
If you violate this, the state can and probably will file a violation of a protective order. This includes you cannot text them, you cannot message them, you cannot use social media to reach out to them, you cannot use, Snapchat, you cannot use someone else to try to get in contact with them. No contact whatsoever. Do you understand?
I do.
This order is good for 61 days from today. So if you go over there, it's going to be an issue. You understand?
I do.
Okay, so I want to sign first now the MOA,
Okay.
and then after that, we'll now do the plea again.
It's in your
It's here, Jack. Judge.
Mr. Lopez, I want to protect every person in my county, and I'm going to do it at all costs. Do you understand?
I do.
All right, so let's do this plea again. You're now charged again with the offensive terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. They've offered you 50 days in jail, credit for the 9 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. There is an affirmative finding of family violence. How do you plead on this case? Guilty or not guilty?
Guilty.
I'm going to find you guilty. Now we will sentence you on the case. All right. Good luck to you, Mr. Lopez. Make me proud, man. That's all I'm asking you to do. All right. I guess let's just appoint someone else because I don't want to wait. It's already noon. I'm going to give you a PR bond,
Thank you, Judge.
but I need to give you a lawyer first before we can start talking about your case.
Yes, sir.
But you got to come back.
I am, Judge. I
Yeah,
promise.
come back.
Promise I am. I pull out all my hair and everything, all my dreads. Pull out all my dreads.
It'll be fun, my friend.
Stressing.
All right, so just hang tight. Sorry. Let me just get him another lawyer real quick. I'm gonna bring it back out. We'll talk and then we'll get you out of here.
Thank you.
Hey,